Okay. So, Shilpa, please introduce yourself.
My name is Shilpa Rani. I am from Madhubani district of Bihar. I have done my BA LLB from National Law University Ranchi in 2019. Since then, I have been preparing for judicial services. This is my second attempt at Bihar Judicial Services.
Okay. So, इससे पहले आपने कहीं और का एग्जाम दिया है? Other than Bihar?
मैम यूपी का मैंने इंटरव्यू अपीयर किया था.
So you have appeared for Bihar interview as well as UP interview.
Yes.
ठीक है. Other than that?
I would be appearing in Jharkhand mains. I have qualified pre.
Okay, you have also qualified Jharkhand prelims. You will be appearing for Jharkhand mains.
Yes.
तो उसकी तो I think अभी date announce नहीं हुई है.
No, ma'am.
So what will happen if you get selected in Bihar? Are you still preferring Jharkhand over Bihar?
No, ma'am. Being my Bihar is my home state, so Bihar is my preferred choice.
So that means you will not appear for the mains then.
No, ma'am.
Okay, ठीक है. So कोई आपने कोई चीज discover करी that what was the reason that last time you were not able to clear the interview?
Yes, ma'am. कुछ गलतियाँ हुई थी वहाँ पे. The first being nervous हो जाना, और दूसरी मेजर गलती मेरे साइड से ये रही कि मैंने थोड़े से बुकिश लैंग्वेज को याद करने की कोशिश की. लाइक व्हेन दे आस्क्ड कि डिफाइन certain crime like criminal intimidation. So instead of saying that in general language, I got nervous and tried to explain कि exactly IPC में क्या लिखा है.
Okay.
So there were a lot of fillers in the definition. So that would be the one reason.
So talking about nervousness, have you worked upon it?
Yes, ma'am.
How? What did you do
Ma'am,
for that?
Beside like working on my knowledge of law, I did some breathing exercise, and in UP it reflected well. Like I got good score in interviews but less marks in GK, so that went against me. Other than that, I started pursuing masters from Delhi University to like gain a depth of the subjects. So
what
in
was
this
your area of specialization in masters?
There is no specific area of specialization. It's a general masters of law. We have been given a list of subjects and we opt some of them. My inclination in particularly is towards criminal law.
Okay, ठीक है. Okay, so I can see you are from Madhubani.
Yes.
So there is one famous feature about this place. इसका एक बहुत popular, it is popular for one thing, that is?
The one thing it is quite popular is its painting. Other than that, it's also famous for makhana.
Can you tell me some peculiar features of Madhubani painting that is very famous?
Ma'am, in Madhubani painting, there is a use of natural colors. The brushes are made of bamboos, and other than these materials used, the natural things are used to depict, used as symbols. Like the fish is used as a symbol of. I'm confused with like their symbols are used. Like elephant is used for generations. And the paintings are made by using these symbols like turtle, the dove, the peacock.
You should know about, I think you should know in and out about Madhubani painting because you belong to that place. Alright, so you are not sure about these symbolic inferences of these figures like fishes and elephants and everything?
I don't in particular make Madhubani paintings, but
Okay.
I have some. I know people who makes them, so I have seen them. I have like read about them and participated in conversation regarding Madhubani painting. But in particularly, since I don't practice and paint, I lack these precise information.
So you have completed your LLB in 2019.
Yes, ma'am.
So you have been preparing for judicial services since then?
Yes, ma'am.
Never worked or कोई एक्सपीरियंस और कोई नहीं है आपको? कहीं पे आपने काम नहीं किया, कभी लिटिगेशन या प्रैक्टिस नहीं करी आपने?
नहीं मैम, पर्टिकुलरली मेरी इंक्लिनेशन प्रैक्टिस की तरफ नहीं थी. स्लाइटली मेरी इंक्लिनेशन एकेडमिक्स की तरफ थी, बट दैट डेवलप्ड लेटर. एंड स्टार्टिंग BA LLB करते के साथ ही आई वाज थिंकिंग कि नहीं जुडिशरी में जाना है. एंड
Why so?
मैम मेनली 3 रीजंस हैं. पहला कि एक अच्छा करियर अपॉर्चुनिटी है ये लॉ ग्रेजुएट के लिए, जो कि आपके बेसिक नीड्स को फुलफिल करता है. सेकेंडली आप सोसाइटी को सर्व कर सकते हो सिस्टम का पार्ट बन के. और तीसरा आई थिंक आप सिंस आप सोसाइटी से काफ़ी कुछ गेन करते हो, कुछ सीखते हो, तो इट्स गुड कि आप कुछ उन्हें उनको सर्व करके यू कैन रिपे देम. सो आई थिंक इसलिए मेरा इंक्लिनेशन उनकी जुडिशरी की तरफ ज़्यादा था.
से जो आपने बेसिक नीड या करियर अपॉर्चुनिटी की बात की, what I can infer from that is you're talking about some kind of financial stability and career security, right?
Yes, ma'am.
So आपने जुडिशरी चूज किया बिकॉज उसका एक वन रीजन ये है बिकॉज इट इज अ गवर्नमेंट जॉब, तो एक सिक्योरिटी है. इज दिस ट्रू?
Ma'am, this is the one reason, but then this applies to many other services as well. लेकिन एक सोसाइटी को सर्व कर पाना ये इसका एक मेजर फैक्टर ये भी था कंसिडर करने के लिए. And in particularly, if one is opting for any job, तो financially security and stability is the factor to be considered.
Okay. And even अगर सोसाइटी को सर्व करने की भी बात है, तो that also you can do by litigation also. I think ज़्यादा better तरीके से आप कर पाओगे. You will be able to help the needy ones in a better way if you go for litigation. Why only judiciary? Why do you want to become a judicial officer?
Ma'am, apart from these reasons I have shared, I think I would not be doing justice with the practice because I'd never feel kind of inclined towards the being an advocate. So that is the major reason I didn't think about joining practice.
So anyone from law background in your family?
No, ma'am, I'm the first generation.
Okay, then what was your inspiration?
In school, my principal advised me to appear for CLAT. That was the one of the motivating factor. And other than, my grandfather wanted someone in family to pursue law.
So what I can infer is सिर्फ या तो प्रिंसिपल के कहने पे या अपने ग्रैंडफादर के कहने पे आपने लॉ ऑप्ट किया है. Your personal inclination towards it was not there.
As I have said, I am from Madhubani in Bihar. The literacy rate is pretty low. The girls are they get married around 20. So thinking of a career was not a part of my childhood. It developed later when I joined the joined my 10th the school where I did my matriculation. So my principal was a major career counselor at that time for me. So joining law field and doing LLB, he played an important role in that.
Okay, ठीक है. What according to you are traits of an ideal judicial officer?
One of the best characteristic of an ideal judicial officer is that he should be very decisive, very look at the things very objectively and take decision. Also, he should be impartial and not affected by any kind of biasness. Thirdly, he should be have empathy towards the society. Also, at the same time, he should be kind of not so much connected with the society because else that would affect his impartiality. And other than that, I also think that a judicial officer should be very punctual.
आपके अंदर है ये सब qualities?
I believe है and I'm working on them.
Can you justify?
The one would be I reached there here at 125 sharp.
सिर्फ पंक्चुअलिटी? डू यू थिंक सिर्फ पंक्चुअल होने से वो तो एक एडवोकेट को भी होना चाहिए, वो एक टीचर को भी होना चाहिए, वो एक डॉक्टर को भी होना चाहिए बिकॉज डॉक्टर्स आर ऑल्सो सेविंग लाइव्स. उनके लिए भी पंक्चुअलिटी इज वेरी इंपॉर्टेंट.
बट इन एनी प्रोफेशन
एनी अदर रीजन जो कि अगर आप हमें जस्टिफाई करोगे कि ठीक है वी शुड सिलेक्ट यू, कि कोई ऐसा कंपेलिंग रीजन कि भाई हम आपको सिलेक्ट करें, तो यू हैव टू जस्टिफाई इट.
I think I can listen to the person before me very patiently and can take a decision. So I can decide based on the facts that is before me and applying the law that has been uh, existing.
Okay, ठीक है. So
तो शिल्पा, आपने बताया कि आपके फेवरेट क्रिमिनल लॉज हैं,
सर
तो आपने नए वाले क्रिमिनल लॉज पढ़े हैं अभी तक?
सर मैंने लॉट एग्जैक्टली थॉरोली नहीं पढ़ा है, बट हाँ.
कौन सा पार्ट पढ़ा आपने? बीएनएस, बीएसए, बीएनएसएस?
सर लाइक आई सेड, मैंने थॉरोली किसी को नहीं पढ़ा है, बट एन ओवरव्यू मैंने तीनों के लिए है.
ओके, चलो मेरे को आप ओवरव्यू बता दो. व्हाट आर द चेंजेस मेड विद रिस्पेक्ट टू द इन्वेस्टिगेशन पार्ट अंडर बीएनएसएस?
सर एक BNSS में जो बहुत ही रिमार्केबल चेंजेस आए हैं वो ये है कि आपको चार्जशीट 90 डेज़ के अंदर फाइल करने को के लिए मैंडेटरी किया गया है. तो एक ये स्पीडी जस्टिस को हम बोल सकते हैं कि ये है. दूसरा सर and other than this I cannot recall, but registration of FIR, maybe there are changes, but I'm confusing that with arrest. So
ओके, क्या अरेस्ट में क्या चेंजेस हैं?
सर अर्लियर ये प्रोविजन नहीं था कि आपको SP के कंसेंट चाहिए फॉर द थिंक द पनिशमेंट. अगर इफ वन इज अक्यूज्ड ऑफ एन एनी ऑफेंस that is punishable with 3 years or less than, then in that case the consent of SP is required before arresting that person. So this is the new thing that has been added to BNSS.
Okay, so you just talked about speedy justice. Would you say speedy justice is the way forward? That justice should be at a speedy pace? Is it correct? Like अगर जल्दी होगा तो better होगा?
Sir, it is incorrect. It would be incorrect to say कि अगर जल्दी होगा तो सही होगा, लेकिन अगर ज़्यादा लेट होगा तो देयर आर चांसेस कि गलत होगा.
Okay.
And
तो अगर हम फॉर एग्जांपल ऐसे टाइमलाइंस एस्टैब्लिश कर देंगे which have been done in BNSS,
yes sir.
don't you think it will affect the very duties of the police officer while investigation as well as the judges, because they will be in a hurry in order to complete the particular process?
Sir, I don't think they would be in hurry to complete the process, whether it's judge or police officer. But एक timeline अगर set हो जाएगा, then it would be like an object कि हमें इतने time तक finish करना है. And also एक timeline fix करने का major reason what I think is कि उस time के बाद evidence के destroy होने के या फिर tampered होने के chances ज़्यादा हैं.
लेकिन concoct होने के भी ज़्यादा हैं, stock witnesses के होने के ज़्यादा हैं, false evidences लाने के ज़्यादा हैं, forceful confession करवाने के ज़्यादा हैं. Don't you think so?
सर फोर्सफुल कन्फेशन तो अगर पुलिस के सामने किया है तो उसका रेलेवेंस नहीं होगा. एंड ये सारे चांसेस हम टाइम लिमिट दें या ना दें उनमें भी पॉसिबल है. बट जो एक मेजर ड्रॉबैक है अभी के जस्टिस सिस्टम का कि बहुत सारे केसेस पेंडिंग हैं. तो उसके
पहले जब CRPC था, when CRPC was the procedural law, तब नहीं था कुछ स्पीडी प्रोसेस कंप्लीट करने के लिए कोई प्रोविजन?
सर था सर, हमारे पास CRPC का आई थिंक इट वाज सेक्शन 309 जो कि बोल दैट स्टेटेड कि आपको ज़्यादा एडजर्टमेंट्स नहीं देने हैं एंड ट्रायल जल्दी से कंडक्ट करना है. इवन सबमिशन ऑफ फर्स्ट इन्फॉर्मेशन रिपोर्ट आफ्टर सबमिशन ऑफ पुलिस रिपोर्ट में भी ये प्रोविजन था कि यू शुड सबमिट इट एज सुन एज पॉसिबल. बट एक टाइमलाइन ये देना, दिस इज लाइक गिविंग अ गाइडलाइन विच इज़ वेरी नेसेसरी like for the execution of laws. So I think this is
that as soon as possible. How do you interpret that word, which was earlier there?
Yes sir, the as soon as possible, it's a very ambiguous expression. So I think it's a good step to that the timeline has been fixed.
What if I say that it is in accordance with the circumstance, because as soon as possible shows whatever is reasonably required?
Yes sir.
So instead of it being ambiguous, I would say it is appropriate according to the case. And if there is a delay, supposedly on part of the police or any other authority, they will be responsible for the same. I believe as soon as possible fits in this giving of justice better than the timeline, stipulated timeline. What are your views on the same?
Sir, I think the facts and circumstances of the cases are different. Like for different case, it differs. But also, if 90 days, I don't think is quite a minimum we can say. But I think as soon as is more ambiguous, so fixing timeline is better in my opinion.
Can you recall any particular judgment by Supreme Court where even it derogated the practice where the high courts would stipulate a timeline for the trial courts from time to time that you need to complete this trial within a stipulated time period? So the Supreme Court even criticized it several times that timelines should not be prescribed because they put a lot of pressure on the trial judge for completing the trial within a stipulated time.
Okay,
And that may deviate the practice of giving and granting of justice as well.
Sir, I will have to read on that. I cannot recall.
Okay. आपके option subjects क्या क्या थे?
Sir, the पहला constitution and administrative law, दूसरा transfer of property, specific relief act, trust and equity, and the third one was law of contract and tort.
Okay. So I'm going to ask you a few questions regarding constitution.
Yes.
ठीक है? अभी recent में एक judgment आया था regarding Article 30.
Yes, sir.
Can you recall the judgment?
Sir, yesterday only the Supreme Court said regarding the minority institution status of AMU. Initially, in 1967, a judgment was passed, Aziz Baza case, which said that since AMU has been established by the Act of Parliament, it is not a minority institution. But yesterday, the Honorable Court said that just because it has been established under the Act of Parliament, it does not fail to be a minority institution. But the final decision is yet to be made.
So what was the decision yesterday? If there was no final decision.
They said that Aziz Baza case is no more applicable, but whether any minority institution that has been established under the Act of Parliament can be said to enjoy the fundamental right that has been given under Article 30 or not, it's a matter that would be decided by the bench otherwise.
Then what was decided yesterday? If this is to be decided precisely,
yes,
then what was decided yesterday then?
So this is I need to read in detail, so I'll read.
Because as far as I can recall, it's the constitutional bench which has said that minority status is
Yes,
not
sir,
gone,
that was constitutional
right?
bench.
Because it is not a correct presumption to take that just because you were born and established out of a statute, it will take away or snatch away your minority status, right?
Yes, sir.
The thing is, AMU status is not yet decided. Whether
Yes, sir,
AMU is
sorry.
a minority
Yes, sir.
institution or not, that is yet to be decided.
Yes, sir, sorry for that
So
confusion.
apart from this Article 30, do you have any other provision in the Constitution which specifically tries to protect the interest of minority?
Sorry, sir, I cannot recall.
Can you recall Article 29?
Yes, sir, that's
क्या
guarantees
है
that.
Article 29 में?
It's regarding that they can. Sorry, sir, I cannot recall the wordings.
अभी एक थोड़ी देर पहले एक और जजमेंट में पढ़ रहा था कॉन्स्टिट्यूशन के रिगार्डिंग थी. It was right to property. Regarding
sir.
the private property with respect to Article 39 Clause A, which is the DPSP.
Sorry, sir, I think it's 39 Clause B.
39 Clause B. Okay.
Yes.
What was the judgment therein?
See, it's earlier the view was that the every private property can be used as material resource for the community. The Article 39B provides for the distribution of material resources. But in this case, it has been held that we cannot say that every private property is the material resource for the community, and it gave the guidelines that the owners would be notified and the matters would be discussed.
So what is the status of right to property? If we talk about in the present context, what is the status of right to property?
So it is a constitutional
Kindly
right.
provide along with the provisions that we have right now and that were earlier under the Constitution.
So earlier right to property was a fundamental right guaranteed under Article 19, and after 44th Amendment Act, it was removed as a fundamental right but inserted as a constitutional right under Article 300A.
Okay. And right now, are there other provisions under the, I would say, DPSP which has any kind of conflict between them?
Sorry, sir, I couldn't get the question.
Any particular provision in the DPSP which
Yes.
in any way interfere with the right to property?
Sir, one I can think of is the 39C that provides that means of ownership should not be concentrated.
Okay. Apart from this, any other provision? For example, Article 31C.
Uh,
Have you heard about the concept of doctrine of eminent domain?
yes, sir.
Can you elaborate on the same?
Sir, it provides that the state has the ultimate ownership of all the properties. So
State has the
state is the owner of all the properties.
all the property. Isn't it in a direct conflict with Article 300A that you just told me it's a constitutional right of property?
Yes, sir. But then it sorry, sir.
Because in the recent judgment, even Supreme Court reiterated this doctrine and sought this conflict between eminent domain and right to property.
Sir, I'll read on that.
You have in your previous statement, you have already explained it.
Sir, I cannot sum up like right now.
Sorry. So, what is a tort? Tort किसे कहते हैं?
Sir, any civil wrong that has that sir exactly the tort को define करना is tough. There is no settled definition of tort. We have two definitions of one of is Salmond and other is
No,
of
I'm asking
Manfred.
about your definition. Leave Salmond.
Sir, in my opinion, it is a breach of duty that is owed to the other person, and in consequent of which the other party suffers a damage, and to compensate for that, unliquidated damages are provided.
Okay. So supposedly a person is killed.
Sorry, sir.
A person A kills a person B,
Okay, sir.
right? And there is a criminal proceeding which is going on against him. Can, in addition to that criminal proceeding, there be a case for compensation under law of torts for an offence which is committed against a person?
So, in general, a suit can be filed for compensation even if a criminal proceedings is going on. So, in general,
In case
yes.
of murder,
In case of murder, it's I don't think.
can you recall any judgment? Because there was recently a judgment by Supreme Court which specifically dealt with this point.
Sir, sorry, I haven't read that judgment.
Okay. Other subjects you told me that it is contract as well, right?
Yes, sir.
Okay. Contract में आप मेरे को जो section 19 है explain कर सकते हैं?
Yes, sir. Section 9, according to Section 19, अगर कोई contract that in which the consent is influenced by either coercion or fraud or misrepresentation, then the person whose consent is so obtained can can avoid the contract.
Okay. उसके बाद एक और insertion हुआ था 19 के बाद में.
Yes, sir.
Provision.
हाँ, if the person has means to discover the fraud or his consent is not affected by that, I think that was the new addition.
No, any other change apart from section 19 itself? Any other insertion after this?
Yes, so there amendment has removed undue effect of undue influence from section 19 and new section 19A was inserted.
Right. What is the reason for this insertion and this change?
Okay. So the major difference I see in section 19 and 19A is that if someone has obtained something, even though his consent was affected by undue influence, that he has to return that. And I think even though consent is affected by undue influence, the state of thinking is less affected in case of, like, the person is allowed to think. He's being we can say there is a kind of psychological pressure, but the coercion or fraud is more grievous form of affecting the consent. So I think
so therein the person will not be bound to return?
Sorry, sir?
So in case of, let's say, fraud coercion, the person will not be bound to return. if that person wants to avoid the contract.
No, sir, any person who is avoiding voidable contract, he is born to return. It is the anything
How
he.
come there is a differentiation again? Article जो section 1919A है उनमें difference क्या रहेगा फिर?
Sorry, sir. Like